At this juncture, I would like to delve into a lesser talked issue. What is your standpoint on the sanctity of the government order from an administrative law viewpoint?
Now, this issue has also been gone into by the Karnataka High Court. And the Karnataka High Court has found the administrative power to pass this order. At least about 10 pages have been devoted in the judgment as to the administrative competence in the passing of the order. And the High Court has traced this power to the laws on education and the rules that have been promulgated under the Education Act, etc. And it has been found that this power specifically exists in the rules, setting the curriculum in a school and then stipulating a particular uniform in these pre-university colleges. This power exists in law, and so therefore it has been found to be an administratively competent order that was passed by the government, which said that hijab will not be permitted in the pre-university colleges, and there has to be a uniform, and every student must wear that uniform.
So, how would you address the dichotomy between freedom of religion and freedom of conscience?
This question has also been addressed by the Karnataka High Court. Freedom of conscience.
There's a criticism here that the court has addressed the question very lightly. Do you agree with that?
I don't agree with that. The court has addressed this question in sum and substance, and I will try and explain that to the viewers. Freedom of conscience is an internal mental process. So atheism and agnosticism, for example, or a certain belief that I carry in my mind is covered within the ambit of freedom of conscience. And when that belief is manifested, when it is professed, it is propagated, then it becomes freedom of religion. So these are two mutually exclusive concepts, freedom of conscience and freedom of religion. They're distinct concepts. They are mutually exclusive in nature. Now, the Karnataka High Court has said that the whole case of the petitioners was set up on the ground of freedom of religion. And the freedom of conscience was a very weak ground that was taken in some of these writ petitions. It lacked that evidence, or it lacked that material particulars. So therefore, and then the court went ahead and said that they are mutually exclusive. They are distinct in nature. Now, having said that, even if we test hijab on the anvil of freedom of conscience, still hijab will not be in consonance. It will not fall within the ambit of freedom of conscience, because the court has gone ahead and said that hijab is not an essential religious practice in amongst Muslims. It is not essential at all. It has gone into the history of hijab, etc. So even if you apply hijab in the context of freedom of conscience, in my view, the petitioners did not have a case. So it may not be fair to say that the Karnataka High Court has lightly addressed this question or has brushed it aside or something. I would not read the judgment like that.
And the petitioners are heavily relying on the case of Bijoy Emanuel. But I believe the factual matrix in that case was entirely different. What would be your thoughts on that?
Yes, I totally agree with you that the facts in Bijoy Emmanuel are totally different from the factual matrix in the hijab case. there were these innocent school children, and they were part of the Jehovah Witnesses sect, and they got up when the national anthem was being sung, but they did not participate in the singing, but they respectfully got up. So it was in that context that the court observed that it was part of their freedom of religion, freedom of conscience. And the Karnataka High Court has actually, examined this judgment very carefully. And it has come to the conclusion that apart from the distinguishing facts, there is a blurring in Bijoy Emanuel as to the distinction between freedom of conscience and freedom of religion. And the Karnataka High Court says that perhaps the Bijoy Emmanuel judgment transcends freedom of conscience, and it was more to do with freedom of religion. But then the Karnataka High Court said that it may not be an appropriate precedent that can be applied to the hijab controversy.
With this lucid explanation, let's now play devil's advocate.
Yes.
So, in upholding the hijab ban, did the High Court fail to envision a pluralistic and diversified society?
Not at all. In fact, pluralism and diversity in the society are upheld by the judgment. Pluralism doesn't mean indiscipline. Pluralism cannot be applied blindly in every sphere of the society, in every social sphere, in every human activity. We are a pluralistic society. We are a diversified society. But there has to be some unifying force. Now, it can't be applied. Now, for example, wearing the hijab in the marketplace or in a function, in a social function, it is in accordance with the pluralistic society. But wearing the hijab in a school or in a pre-university college, there you need discipline, there you need uniformity, there you need homogeneity. So uniformity, homogeneity, discipline, they are not anti-pluralism or diversity in the society. Diversity and pluralism cannot be applied, in every sphere of the society under the same benchmark. So the discipline demands that, the students wear the same uniform when they come to a school, or when they go to a pre-university college, or when they go to any space where there is requirement of discipline and uniformity. So in my view, it would not be fair to say that the Karnataka High Court has not gone into this aspect of pluralism and diversity in society. It has addressed this issue.
And has the court failed to address the question of right to accommodation?
Not at all. Not at all. Again, the spirit of accommodation cannot be applied mechanically in every situation. For example, in the court of law, when we appear in the court as lawyers, we have a dress code, we have a uniform. Similarly, when you go to a school or college, there has to be a uniform, there has to be discipline. So it is not a question of spirit of accommodation. However, in a marketplace or in a social function in the evening, or in other public areas, or within the confines of my home, I have to be accommodated. The principle of accommodation will apply. I have the freedom of choice to wear what I want. Whether I want to wear the hijab, whether I want to, wear any particular attire, etc. So in these social domains, the spirit of accommodation will apply very differently when compared to, say, in a more disciplined atmosphere like the court of law or a school or a college.
So, with these enlightening views, let me pose a couple of final questions to you. Socio-cultural, political, or legal, how would you tag the whole controversy surrounding the hijab ban?
Whenever any dispute comes to the court, there are two elements of the dispute. One is the factual aspect, and the other is the legal aspect. So I would, in the hijab case, I would call it the factual determination, the factual dispute to be socio-cultural in nature. Definitely not political. It is not a political dispute that went to the court. The factual aspect, in my view, is in the nature of a socio-cultural dispute. And the other side of the coin is the legal aspect of that dispute. So, the case raised numerous constitutional questions and issues that have been addressed by the High Court, and a decision has been finally delivered. It's a meritorious decision in my view, where the facts have been ascertained, facts have been determined, and constitutional principles have been applied to those facts to arrive at a very just decision.
And now that the matter has reached Supreme Court, what are your predictions? How do you see it panning out?
As lawyers and as senior lawyers, I've been at the bar for 3 decades. And, we are always trained not to predict outcomes in the court. Law is not like mathematics, that I can predict. And we are not trained to predict decisions. The matter has gone to the Supreme Court. The Supreme Court will examine the issue and, decide. But since you have now asked me this question, I must not fail to answer it. In my view, the judgment of the Karnataka High Court is very well written. It is complete in all respects. And I repeat, I started by saying that it's a constitutional gem. In my view, it is likely to be, it should be upheld by the Supreme Court. It is likely to be upheld by the Supreme Court, but I can't predict with conclusivity, because that's not a part of our training. It's not a part of our domain. Since the judgment is very meritorious, therefore, in my view, it is likely to be upheld by the Supreme Court, is all I can say.
And all I can hope is that common sense prevails, and all eyes on Supreme Court now.
Definitely. The Supreme Court, I must end by saying that our Supreme Court is the finest law factory in the world. The quantum of law that is churned out and manufactured in the Supreme Court is amazing. Our Supreme Court judges are amongst the finest judges, in the world. And I have the highest regard for the Honorable Supreme Court judges. Of course, the case should be admitted. It will be examined by the learned judges of the Supreme Court. And we will have another constitutional gem that, we, the people of India, can be proud of.
And all I can say is thank you for this gem of an interview. And we look forward to having you again. Thank you for this wonderful interview and your insights.
Thank you.
You have clarified all the points extremely well for the viewers. I don't think there is any scope for doubt or any ambiguity left.